It is 8:32 on WISN. They're the stubborn questions that hang over the Republican primary for governor. Can that 2020 Biden win be reversed in this state? Is it legal or constitutional? If so, is it smart? Well, Rick Esenberg is smart. We know that. He's the founder of the president of the Wisconsin Institute for Law and Liberty, which did its own review of this 2020 election. And he joins me now to tackle some of these questions. Good morning, sir. How are you?
Good morning. How are you doing?
Doing well. Thanks for being on. This has been a point of contention. You have a strong opinion from state lawyers and top GOP lawmakers that the Wisconsin legislature cannot now rescind, decertify, reverse the results of the presidential election. There's been strong opinion of President Trump and some others that it can be done. What say you are whether it can be done or could be done?
It can't be done. Think of it in two different ways. First of all, can it be done under federal law? And really, if you read the end of the Gableman report that was put out earlier this week, they even acknowledged that a decertification by the state would not change the electoral vote count and who would be president. But beyond that, it can't be done under state law. Our United States Constitution does delegate the method of choosing electors to the states in any manner that the state legislature might prescribe. It has prescribed a way, right? It decided that this would be done by popular vote, and it enacted certain statutes with respect to how the results of that vote would be determined. Having done that, it is bound by it, and it can't depart from that until the law is changed. And of course, it had not been subsequent to the controversy following the 2020 election. And so if there was a dispute, and, there certainly were some lawsuits filed and some arguments made with respect to the, validity of the declared outcome of the 2020 election, that had to be adjudicated in court. Right? That had to be taken to court, and courts had to decide whether the law has been decided with. The Gableman report, I think, suggests that the legislature unilaterally could do that. I don't think it can. The legislature makes the law. The legislature does not adjudicate whether the law has been followed. And so I think that, sort of regardless of what you think about the 2020 election and who won and who didn't win and how many problems there were, and there, to be sure, were many, many problems. Mm-hmm. This decertification of electors cannot happen.
Right, and that's important because, should it be done and can it be done are two different questions. It can't be done. Is there any Wisconsin statute that says even after our legislature has verified our results and sent them to the Electoral College, they could be corrected or reversed?
Well, there's always the ability to go to court and argue that the law has not been complied with.
But it has to be done in court.
Yeah. I mean, you begin to run into a problem with respect to, the Electoral Count Act and, when the results of the presidential election become final. But there was an opportunity to go into court and challenge the outcome of the 2020 election, and the Trump campaign did that. It was unsuccessful in doing that. What happened is that it marshaled some arguments. Those arguments were not crazy. They were, Jim Trupis made them on behalf of the president's campaign. They were arguments that were serious, deserved to be taken seriously. But the court concluded by a 4-3 vote that it was too late to bring them up, that they should have been brought up prior to the election, since the campaign knew that some of the irregularities were ongoing prior to the vote. And so it dismissed the claim on the basis of a doctrine called latches, which basically means you can't sit on your rights. Now, whether it was right or whether it was wrong to do so, that's what happened, and that was the end, effectively, of those challenges. I mean, obviously, there are other things that lawyers try, but none of them were very likely to succeed.
And my interest is in clearing this up for voters in fall and Republicans and conservatives. We're talking with Rick Esenberg of Wisconsin Institute of Law and Liberty. We have a state representative, Timothy Ramthun, basing his campaign on this possibility that the legislature could decertify or reverse these results. And he points to Article 1, Section 4 of the state constitution, which says, quote, the power to prescribe the manner of conducting elections is clearly within the province of the legislature. He says that means the legislature has plenary power and a dutiful obligation to remedy any illegalities that take place during the electoral process. Do you agree? And would that even apply going back and changing results? Because that reads to me as if it's more about how elections are run and by whom.
Right. I mean, look, there are multiple problems here. The first is, of course, the legislature has the right to determine what our electoral laws should be. But what I think Representative Rampton is missing here is that it has done that. It established a set of procedures that would govern the 2020 election, and those had to be followed until they were changed. Now, that applies to the legislature, and it also applies to the Wisconsin Election Commission. And so, the fact that there are ways in which I think the Wisconsin Election Commission did not follow the law in 2020. Those are very, very problematic. Those need to be addressed going forward. But the second thing that I think presents a problem is there's always an array of constitutional difficulties that arise when you try to change the law after the fact. And we all should be very, very concerned about any legal argument that says that we can have an election and then the legislature, a partisan body, can decide whether it likes the outcome of the election and then vote to change it or not.
Yes, this to me is the danger of all of this. I'm sorry to cut you off, but this is the danger of all of this talk. It's like we can't have a system in which either party, either side of the aisle, if they have control of the legislature, can therefore decide they just don't like an election result and change it.
Yeah, right. It's a banana republic argument, and you don't want to go down that direction. And even if you're only concerned about partisan self-interest, which you shouldn't be, your concern should be broader than that. The one thing that we know is that there are no permanent victories in politics. We can be relatively sure that if the Republicans control the legislature today, there will be some day in the future when the Democrats control it. And do we really want to give a partisan body that type of power? I don't think we do. I think that there were issues that were that arose in the wake of the 2020 election. Some of them never got litigated. Some of them did. The people that brought the claim were not successful. Maybe they should have been. They weren't. And I think what's important right now is to look at what happened in 2020, as we did in our report and others have done, and decide what type of reforms we need to make going forward so we can be sure that in the future we will have more confidence and we will be we will feel better about the security of our electoral process than many of us did in 2020.
And then just finally to sort of button up this line of questioning before I want to move on to something else, I think Janelle Branchin made a salient point when she said the other day, if boxes of ballots are found later that could change the outcome of an election, Wisconsin has no law or procedure that spells out how to correct that error. That may be true, but what I hear you saying is the remedy is the court system. The remedy is through the court system, a different branch of government. The remedy is not lawmakers going back and looking at it.
Right, and you probably wouldn't have, even if you did find a bunch of ballots here in March of 2022, you probably wouldn't have a judicial remedy anymore with respect to the 2020 election. I think that's, there is a point at which the only way to change an office holder is through the impeachment process. And so let's say that we uncovered a massive scheme tomorrow that proved beyond doubt that Joe Biden had stolen the 2020 election. The remedy for that would be through the impeachment process at this point, and that would become a political matter. But when we're talking about contesting the outcome of whether an election was held properly or improperly, or whether the votes were counted or not counted properly, there's a window of time to do that after the election, and it needs to be done in court. That's what happened in Bush versus Gore. In fact, we had a Wisconsin gubernatorial race shortly after we became a state in the middle of the 19th century that was wound up being adjudicated by the Wisconsin Supreme Court. Armed militias were marching on Madison to fight over who was going to be governor, and the matter went to court, and the court resolved it.
Well, just to voice the frustration that I'm sure is out there in the conservative audience, what's frustrating about going to court is that time and again we seem to have courts, the issues after the election has been held, issues go to court, and it seemed to happen in 2020. You had a number of conservative groups and and interested parties that went to court to say this was fraudulent, that was fraudulent. We got to look more closely. And the courts, no, the time to bring that up was before the election. So the courts have been less than serious, I think, about taking on vote fraud in this state.
It's always very difficult to get a court to intervene and change the outcome of the election. Believe me, somebody who has spent, 40 years litigating cases, I can get frustrated by courts as, I got more court frustration stories to tell than you have the patience to hear. But, there is a point in all of that, and that is that, when you think that a government agency has gone off the rails with respect to the way it is conducting an election, it is very important to bring that challenge prior to the election, which is one of the reasons why, we're going to be arguing in April, before the Wisconsin Supreme Court with respect to the legality of these ballot drop boxes and ballot harvesting, because to challenge that after the election, right, when voters were told that they could vote that way, it's very, very difficult to go into a court and ask a court to throw their votes out. It's really important to do it prior to the election, and that's what we're trying to do in this case.
We're talking with Rick Esenberg of the Wisconsin Institute of Law and Liberty. I also wanted to ask you about a Will press release that hit my email or my mailbox this week. Your attorneys at Will are demanding that the Governor Evers administration explain how they thought they could form several new grant programs in order to dole out this federal money to left-wing organizations. A couple of grant programs were apparently created to send money to Planned Parenthood. Can you just walk us through the maneuver that you believe is illegal here that the Evers administration has made?
Right. So there are two different issues here. I mean, the Evers administration has a bunch of money that it got from the federal government and now wants to dole it out. I suppose dole it out in a way which will improve its political prospects. It doesn't shock me. That's what politicians do. But there are two problems. The first is generally with respect to the program. The governor is charged with executing the laws. The legislature appropriates the law, the funds, and can the governor simply create programs out of whole cloth, programs that the legislature never created, that do not exist, and simply hand out the money because he was given it by the federal government? That would allow the federal government, it would allow Congress and the president to make law and create programs here in the state of Wisconsin, and we don't think that Duke can do that, so we've asked the governor how it is that he's spending any money at all unless he can point to authorization in state law that permits him to do so. The second is that there are some particular federal prohibitions against certain types of funds finding their way to organizations that undertake certain activities related to abortion, including Planned Parenthood, and we've asked him to justify the making of grants to those agencies. So there's two separate issues. We sent him the letter. I hope he responds. I hope he's learned by now that he has to take our letter seriously because these issues will not just go away.
Well, and I'm wondering if you have plaintiffs to sue over this if you get no response. I assume yes.
Yeah, they'll be. Look, okay. If there's not adequate legal justification for this, there will be litigation.
Well, and according to your press release, if I'm characterizing it correctly, and if I'm not, of course, correct me. State law permits the governor to channel this federal money, into quote appropriate agencies. It does not say feel free to make up new groups and grant programs. So, right?
That's right.
Okay, so go ahead.
Yeah, that's right. There's also an issue with respect to whether or not rulemaking has to be undertaken with respect to some of these programs. So, right, you can get the money, but that's only step one. Step two is you need legal authorization to spend it in the way you want to.
Okay, so that sort of covers what I wanted to cover, but I hesitate to give you a scale of 1 to 10 because I know legal matters are complicated, but you're asking the Evers team to cite what legal authority they believe they have to not only, create grant programs with no legislative input, which is illegal, but then how they think they can, break a state law that bans government funding to go to entities that provide abortion services, which is Planned Parenthood. You also believe they're breaking that clear statute. So I just wanted to ask you on a scale of 1 to 10, how flagrant is the violation of the law here? Are Evers and his team blatantly ignoring clear statute? Are they working around the edges? Is that a question you feel comfortable answering?
Well, I think with respect to, I would look at it this way. With respect to the Planned Parenthood money, we seem to have, at least in certain instances, some direct prohibitions, and I don't know how he gets around them. In the second instance, we really don't see, again, in some cases, where the authority lies for the spending programs that have been announced. And we're asking, because, we could have overlooked it, we could be wrong. We're asking, can you justify doing this? If you can justify doing it, then that's fine.
Right.
But if you can't, then this becomes a more serious issue.
Well, it's always interesting to speak with you, and this has been a clarifying segment for me. So thank you. Rick Esenberg of the Wisconsin Institute of Law and Liberty. Thanks for being on.
Thanks, Jay. Take care.
Yep.